24, this writ petition is filed by the landowners with a direction that the SRO Kisara is entertaining sale deeds submitted by members of the fourth respondent association, claiming themselves to be individual plot owners of, and that the land in question is an agricultural land, not converted, and the layout which they sought to claim is also a fake layout, and based on that layout and the prayer is this: action of the third respondent SRO Kisara in return the representation dated so and so, endorsing that registration of any property are not stopped unless any restraint order from competent court as illegal, arbitrary, and violation of so and so. And to direct R3 not to entertain and register any deed which are likely to be presented by plot purchasers in an illegal and unauthorized layout in survey number so and so of Rampally village. Yes. And the interim order that was passed in this case dated 1/5/2024. Interim order. Kindly see the interim order dated 1/5. Since the subject property is still classified as agricultural land in government records, and the competent authority to deal with the subject property for the purpose of registration is Tahsildar Kisaraman Mandal Metchal Malkajgiri, who is not arrayed as a party in the present restriction unless lands are divided, converted into non-agricultural land. The same cannot be treated as plot. There shall be an order of status quo to be maintained by both parties in all respect for a period of 4 weeks. The IO was continuously extended, and last of the extension was on 19th September 24 until further orders. 19th September 2024. Yes. In the light of the observation of the court that the Tahsildar is not made a party, IA 4 of 2024 was filed to implead the Tahsildar Kisara Mandal. The same is pending, IA 4 of 24. Okay, IA 4 will allow. What do you say, senior? We'll allow this simplification, then we'll. Okay, IA 4 of 2024. Yes, madam, take notice. IA 4 of 2024, obligation filed to implead proposed respondent as respondent number 5 in the requisition. Lord Counsel for Prisoner as well as Lord Senior Counsel for Prisoner and Lord Senior Counsel applying for the unofficial respondent. Having regard to reasons as well as submissions made, also in view of no objection reported by respondent, here is ordered. Proposed respondent 5 is implemented as respondent 5 to the requisition. Please the director to carry out the amendments
Learn AGP, learn GP Parveen takes notice for response number 5. Further notice 5. Yes, proceed.
Okay. Now, coming to the writ section 22823 of 19, kindly see the interim order. Dated 22/10/2019. As I pointed out, this writ petition was filed by Plot Owners Association, challenging the order of Joint Collector in refusing to mutate their names. 22/10/19.
Yes.
Kindly see the prayer in 1 of 2019 therein, seeking to direct respondent 5 to 7 and 9 to 17 or anyone claiming through them not to sell lands covered by layout number 1 of Rampally village in survey number so and so, which are not part of Nagar municipality so and so, pending disposal of so and so. Now the order is notice Lord Counsel for Kevitar, an official respondent, fairly state that during pendency of the writ petition, Kevitar respondent will not create any third party interest. Same is taken on record.
Apart from the prisoners, there were other response also there.
In that in writ petition,
Unofficial response apart from this prisoners, there's some other also there.
correct. 11 to 17 are the other response.
Only 4 are there. Present 11, double 9%, only 4 prisoners are there.
Yes. From 5 to 17 are the unofficial respondents who appeared there for 5 to.
Prisoners are 5, 7, 9, 10.
Correct.
Yes. So interim order,
there was a
not to create
caveat at that time.
Not to create any third party.
Correct.
Right.
So the situation as it stands now, the order of the Joint Collector refusing to mutate the names of the plot owners is pending consideration by the court, and there is an undertaking by the landowners herein not to create any third party interest. During this pendency, the plot owners, individual plot owners, sought to present documents as if they are plots and not agricultural land. And were trying to create third party interest, which necessitated filing of the WP 11957. And the interim order, the court has already seen the circumstances under which the interim order was passed. But since the subject property is still classified as agricultural land.
But when interim order already there.
Yes.
So that is your okay, right. So effectively both are in fact tied by these orders.
That's right.
Create, they can also create.
That's right. Therefore, the question of vacating it at this juncture would not arise.
Unless all are
correct. The finding of the Joint Collector, if I may point out, yes, in my writ petition, the court 11957, page number 129. One 129. That's got page 129. It's a revision filed by Laxmi Nagar Owners and Housing Welfare Association, not individual, and welfare association, be that it may. Kindly see the order.
9/9/2019.
Correct, 9/9/2019. As against with the other writ petition is one. Now kindly see this order. He has narrated various issues. I may not take the court in extenso about all these things. The order is at page 133. Second para of that order. The
Yes.
petitioner solely relied on the so-called GPA 197, which is void of any detail of schedule. Devoid. It should be devoid of any detail of scheduled property. As said, the subsequent document executed based on such GPA do not hold good in the eye of law. Also, it is observed the layout claimed by the petitioner is reported to be non-existent, and the RDO Kisara has rightly held subject land is deemed to be agricultural land. The petitioners have failed to establish the flow of title in their favor and legality of the layout approval. In view of the fact, I do not find any reason to interfere with the order passed by the RDO Kisara. So and so, accordingly, the revision is dismissed. That is what is in challenge in the other writ petition. Two aspects the authority has conclusively drawn inference that the GPA does not show details of the scheduled property through which they claim to have purchased, and therefore those documents could not be taken into account, and the layout claimed by the petitioner is non-existent. That's the crux of the issue.
Who has filed the suit? Who is 582?
582 is a partition suit amongst the family members of the
Petitioners hearing.
petitioners.
So the final decree passed.
Final decree is passed. I may point out they had filed a suit challenging that final decree position.
What is the status now?
That suit, I am told, is recently decreed and an appeal is filed. That suit is OS 1688 of 2016. I have filed the plain copy. Yeah. And 1/8/2025, that suit is decreed granting the prayer of cancellation of the final decree obtained by the landlords.
Now this challenge?
That is challenged in AS 66 of 25, now pending on the file of second additional district judge. The stools.
Really automatic.
In all fairness, the respondents in that appeal should have come forward with another counsel, but it didn't happen. A couple of adjournments had to be made on that. Therefore, the court has ordered fresh notice to the.
Everybody is aware, but
everybody is. They are taking advantage of the unfortunate demise of that counsel.
Go for publication.
And now they are coming and pressing.
Go for publication and then proceed.
No, we are taking steps in that regard because courts immediately will not grant a publication. Normally, notice is ordered. Correct. The procedure is that.
Because so many. How many respondents? I think number of respondents.
There are a number of respondents. I think 16 respondents. And that appeal now stands posted to 4th of May. In this backdrop, so far as the vacate stay petition is concerned, my submission is twofold. One is, here is a situation where the joint collector has categorically held that the layout is non-existent and they could not be treated as plot holders, and their GPA is also unacceptable. And that land being agricultural land, even as on today, the sub-registrar cannot entertain any sale deeds that may be executed by the members of the fourth respondent association and seek to register it as if it is a plot duly converted and all that, because the conversion has not happened. It's agricultural land. The JC also recorded it. No conversion order is also filed. But what they are doing is individually they are seeking conversion. That's why the other two writ petition.
Individually.
What they do, I mean, municipality HMD also has got a peculiar thing. I apply for my plot, they take
Regularization they will say.
regularize. They will
Regularization
regularize. My neighbors will not have regularized, but I will be a regular plot holder. It enables me to sell my plot. That's the mischief that happens in this case.
Suppose say that, but that also one of the interesting point. Suppose there 200 plots are there, only one plot owner applied for LRS and that is approved. What about 199?
Correct.
There is some.
It's a pure anomaly. If they say that there was a layout, I'm not saying there was a layout, and the plot holders in general, not merely this, if they have purchased 200 individual plots, the layout entirely has to be regularized. Then each of them get their right. But regularizing individual plots in the middle, here, there.
But suppose say out of 200, 50, 150 in fact they're interested in regularizing.
Correct.
50 they don't want
quite a possibility.
regularization.
Quite a
No
possibility. We see
possibility.
the
We don't want
difficulties of plot holders. But unfortunately, what is missed in all these things, that they go together or don't go together. We are all part of one group of, like flat owners. If one flat owner goes the other way, all six have to suffer. The reality is they have to go together. That aspect is being.
What are the grounds in?
Yes, sir. Now, therefore, in the light of this background of fact, the interim order passed was justified. Interim order dated 1/5/24 is justified, because what would happen is, if the interim order is to be vacated, individual plot holders now will go on selling it. I have already given an undertaking, I will not alienate the property, which is recorded in the other writ petition.
Yes,
and if they go on selling, it creates any number of things. These things require a hearing.
Wait, please,
Subject to
what I'll tell you, Lordship, what my friend has omitted to tell you. Lord, it's very generous of the petitioner to say we will not alienate for the reason that there's no title. The Lordship sees, my Lord, please see, I prepared a small list of dates. My Lord, they have no title as it is.
Ask them to all sit down. Why unnecessary?
But they have been on our backs, my Lord. We've been tolerating. I'm sorry. You have put also to inconvenience. My Lord, please see. My Lord, the fourth respondent is a registered, my Lord, Plot Owners Housing Welfare Association. My Lord, the first thing is 9/11/1967. One Maganti Rammohan Rao, along with 13 others, purchased land of an extent of, my Lord, 59 acres, 29 guntas, in survey numbers 381, 382, 383, 384, 387 of Rampally village, Medchal Taluk, Hyderabad district, by a registered sale deed dated 29/11/1967, bearing document number 11643 of 1967 from Jammal Krishnamma, wife of Narsaya, age so and so, and Jammal Durgaya, so and so. My Lord, These are the persons through him, my lord, the writ petitions are claiming, saying they're my grandmother or great grandmother. Then, my lord, age 60 years and 11 other persons. Writ petitions claim to be to the subject land is through Jammala Krishnamma and Jammala Durgaya. My lord, for a minute, please see page 34, my lord, of the material papers which are enclosed in the vacate petition, my lord, that is IA 3 of 2024. Sale deed is there. Now, very curiously, what was read to your lordship is a proceeding of the RDO which says that, my lord, the GPA referred in the sale deed is, my lord, bad. I don't know how he can say that when there's a sale deed of the year 1967. Please see, my lord, page 45. My lord, we have the, my lord, the original Xerox copy at page, my lord, 34 and a neat copy at 45. Please see, my lord, the first two, my lord, vendors in the sale deed are the persons through whom, my lord, petitioners are claiming. Now, the entire land has been sold. Then please see, my lord, this sale deed also refers, my lord, please see, to, my lord, your lordship will go to page, my lord, 47. My lord, whereas vendors 1 to 11 above have entered into an agreement of sale previously of the scheduled land to vendors numbers 12 and 13 above are nominees, and the said vendors 12 and 13 have nominated the purchasers above or of the persons in whose favor sale deed and scheduled land is to be executed have a joint right in execution of this document. Then please see, my lord, vendors applied to the Tahsildar Medchal for permission to make permanent alienation of scheduled land, and the Tahsildar Medchal permitted the alienation of the scheduled land in proceedings so and so, dated 7/11/1967, whereas the Pattadar vendors 1 to 11 above have not been cultivating the scheduled land for long cultivation. There is found to be not remunerative and have therefore kept them vacant for a long time, whereas it's not advantageous to the vendors to keep the scheduled land vacant, paying taxes without deriving any return. Now, this is, my lord, your lordship sees under section 47 of, my lord, the Act. Permission is required to sell land, agriculture, my lord, this Tenancy Act. Then, my lord, and as beneficial to vendors to sell the scheduled land for the purpose of plotting and sale of residence sites, whereas vendors herein have offered the purchasers herein agreed to purchase the scheduled premises of 59 acres so and so for total sale consideration of 99,094 rupees, whereas purchasers of sale consideration on 28/11/67, which vendors do have acknowledged in confirmation of the receipt of so and so, being the balance of sale consideration in cash in the presence of the registrar at the time of registration. All that is stated. Please see next, my lord, there is a reference to a file number and, my lord, a permission by the Gram Panchayat. Then next page, your lordship will find purchase in which forever together with all rights also provided, my lord, possession of the purchase of scheduled land by the vendors to purchasers as per previous agreement included in so and so at Rampally Panchayat, and assure the purchasers that they would reimburse so and so. My lord, there's a reference your lordship will see. Layout plan number 1, dated 27/9/1967 of Rampally Panchayat, and further assure the purchase. My lord, the file number is also mentioned in the original thing, which I'll point out. So, my lord, this is a sale deed executed. And please see, just now my friend led out the RDO's joint collector saying there's an GPA on the basis of which the sale deed is executed. GPA is silent as detail, therefore the sale is bad. I'm not a, first of all, my lord, he has no jurisdiction to decide title. My lord, this is a sale deed of the year 67, where the persons, my lord, writ petitioners, my lord, claiming through, my lord, Kishtama and Durgaya, they were the first persons to sell the entire land. And, my lord, they filed a partition, my lord, so please see, your lordship will see the partition decree, my lord, at page, the suit here, where is it? Please see, my lord, the decree of partition was thing after, my lord, preliminary decree, your lordship will find it page 53. Now, my lord, the person this Maganti Ram Mohan Rao died, my lord. After his death, my lord, he died, my lord, on 15/7/2001. After his death, my lord, a suit has been instituted impleading him as a party. Page 53, please see the preliminary decree. Your Lordship sees, my lord, Anjaya is the first petitioner. He impleads, my lord, two persons, my lord, 3 and 4 defendants, who are the other petitioners, and then, my lord, all the other persons. And at 14, your Lordship will find Maganti Ram Mohan Rao, who is not a member of the family. As I pointed out to your Lordship, he is a purchaser under the 1967 sale deed. Then, my lord, please see the order that's passed. Your Lordship will find, my lord, at page 65. 55, ma'am, sorry. Third, this is a suit for partition to decide the suit property into 11, 13 shares, allot 1/13 share to the plaintiff, D1 to D13 set ex party on 5/11/2023, and D14 set ex party on so and so date. It's deemed that they have no objection to decree. Then affidavit of PW1 filed as exhibit A1 to A5, marked exhibit A1 to A5 scheduled partition, and as defendant set ex party, they have no objection, decree. This is the, my lord, the preliminary decree, which was, my lord, a final decree as page 58. This has been set aside by a suit filed by us, and the trial court, my lord, returned scathing my lord, findings of fraudulent, my lord, documents. So this is the, my lord, the preliminary decree and the final decree, on the basis of which, my lord, they claim title. Please see, they implead, my lord, I can understand if the sale deed, my lord, if there is a prayer in this, my lord, suit, partition suit, implead, my lord, for setting aside the decree that was passed in 67. It was made to appear, he is somehow, my lord, shown as a 14th defendant. Why he is added, nothing is stated. By then he was dead. And this decree came to be passed and the thing. Now please see.
What is the date of death of Ram Mohan Rao?
Yes, my lord, he died.
Date
of death, my lord, I just told your lordship, it is. I'll tell you, my lord. He died on, my lord, 15th July 2001. After his death, the suit came to be instituted on 6/11/2004. And, my lord, this is the decree that attained, and a final decree was passed pursuant thereto. My lord, that was questioned by my clients in a separate suit. My lord, I've filed the decree in IA 1 of 2025, my lord, in WP 11957 of 2024. My lord will find the judgment at page 31.
31.
Yes, my lord. My lord, the entire thing has been the sale deeds have been referred to. Please see, my lord, your lordship will see at page 36, my lord, para 5, plaintiff submitted. Thus, my lord, after setting out the, my lord, your lordship will see at page, my lord, 35 towards the bottom, my lord, they refer to the sale deed that was executed in 1967. And then, my lord, at page 36, my lord, para 5 there, plaintiff submitted. Thus, it is clear that the above pleadings, that on one hand, defendants are claiming that they have inherited the subject land from Srimad Jammala Kistamma and obtained an ex parte decree OS 582 of 2003. On the other hand, they have turned around and stated that Kistamma has no title or right, and they have inherited the property from Sri Jammala Narsaya in WS, my lord, in the written statement, the plea before in this suit. Therefore, from the above contradictory statement, it is clear defendants, by colluding with each other in order to grab the suit properties, obtained an ex parte preliminary decree on 27/8/2004, later obtained a final decree dated 1910-2006 by misleading and playing fraud on the Honorable Court. As such, the same is non-est in the eye of law and therefore is liable to be cancelled. Defendant number 2 herein died before the preliminary decree of the said suit, and he's shown as a pro forma party. Then the plaintiff submitted that on the further perusal of the ex parte decree dated 27/8/2004 in OS 582 of 2003, it's surprising that one Maganti Ram Mohan Rao, the vendor of the plaintiffs, was shown as defendant 14. In fact, by that time, defendant 14 died on 15/7/2001. Plaintiff submitted originally one Ram Mohan Rao and others who are partners of a firm. Rao and partners purchased the lands covered by survey numbers 381, 382, 383, 384, and 387 from the original owners of Jammal Kishnamma and others under the registered sale deed number so and got a layout plan approved by Rampally Panchayat and divided the land into house plots under approved layout number 1 of dated 21/9/1961, thereby formed named Laxmi Nagar colony. Within 5 years thereafter, all the plots were sold out in favor of several purchasers. Some of the original purchasers of the plots sold out their plots, and thus there are several subsequent internal sales also. Plaintiff submitted the plaintiff's colony situated in so. Plaintiff submitted plaintiff number 1 is the president. All that, my lord. Then kindly go to, my lord, page 38, my lord, para 9. Plaintiff submitted, though the alleged decree, which was fraudulently obtained by defendant, is not binding on the plaintiff, since it was obtained by playing fraud on the court, but defendant, by approaching revenue authorities under the guise of the ex parte partition decree, making efforts to get mutation proceedings and Pattadar passbooks in the name, and revenue authorities instructed the plaintiff to approach the court as they have no power to reject, cancel court decree. Moreover, defendants and their family members, all that is stated. Finally, my lord, the decree is set aside. So, your lordship sees, my lord, the joint collector's order saying that the power of attorney given in Ram Mohan Rao is devoid of detail, therefore they have no title, is not, my lord, comprehensible in any manner. First, he has no jurisdiction, and this is a sale deed of the year 1967, and it has never been challenged. And the very persons through whom they claim title, my lord, have no title. And we don't understand why Ram Mohan Rao is shown as a pro forma party. I can understand if allegations are made.
Plain copy is there?
Plain copy, my lord.
That
is
plain copy suit filed by Krishna here. Is there any narration is there? Just check.
No, I don't think plaint in the partition suit has been filed, my lord.
So it's 5 of 2003.
It's not been filed. So, lordship, is at any rate now the decree on the basis of which they are making a claim is, my lord, set aside. Original was, my lord, a registered partition deed. Now the family, my lord, there were 4 lots. All of them, my lord, got 33 acres and 13 cents, and all of them had sold out their land. Right now, there is no land, my lord, in the name of any of the family members. The partition, my lord, deed was of 16 things. So now please see, my lord, the list of dates I have given. And, my lord, the prayer asking the sub-register, my lord, not to register is not maintainable. Your lordship is well aware that, my lord, registration can't be stopped except in terms of the provisions of the Act. Now, my lord, kindly turn to the, my lord, I've already narrated to my lord the depth of this Ram Mohan Rao, then institution of the suit, my lord, over partition suit 582 of 2003, my lord, the decree passed on 12/1/2006, and, my lord, the suit filed by us and the decree and the findings given. An appeal has been filed, my lord, there is no interim order, the decree is in force. Now, primarily, my lord, please see my contention as far as this case is concerned. The writ petition itself is not maintainable. Your lordship, these petitioners cannot persuade this honorable court to issue directions to the sub-register Kisara, the respondent number 3, or even, my lord, the MRO, to undertake an exercise in gross violation of the provisions of the Stamps and Registration Act. Writ petitions are guilty of suppression of facts and acts of fraud in securing a preliminary decree in respect of which land has been sold in the year 1967, and after the death of the Wendy under the sale deed, the case has been instituted. Circumstances under which the registering authority can refuse the registration of a document have been set out in sections 19, 20, 21, 22A and 34 of the Registration Act and the rules made thereunder. Apart from the above, sub-register is required by law to register all documents executed and presented in terms of the relevant provisions of the rules. Then, my lord, about Rule 58, my lord, which says that it forms no part of the registering officer's duty to inquire into the validity of a document brought to him for registration or to attend to any written or verbal protest against registration of a document based on the ground that the executing party had no right to execute the document except in the ground set out. My lord, I will draw your lordship to the rule. Then on the basis of the claim of the petitioners, the basis of the claim of the petitioners is a partition decree granted in OS 582 of 2003. The Honorable Second Additional so, the same was set aside as being fraudulent by a judgment in OS 371 of 2021 dated 1/8/2025. Therefore, the basis of the claim of the petition has been nullified. The Honorable Court, on the basis of oral and documentary evidence, gave scathing findings of fraud and misrepresentation. And therefore, my lord, now please see, my lord, the provisions of the Act where, my lord, registration can be refused. Kindly take, my lord, the Stamps and Registration Act. My lord will be pleased to take all the provisions, my lord. Please take section, my lord, 19. So they can't be, my lord, a direction not to register. Otherwise, I'll read and pass on to my lord. Well, section 19 says documents in language not understood by the registering officer. If any document duly presented for registration be in a language which the registering officer does not understand, which is not commonly used in the district, he shall refuse registration. That is 19. 20, my lord, documents containing interlineations, blanks, erasures, or alteration. Under section 20, that can't be registered. Then, my lord, your lordship will see under 21, description of property and maps of the plan. No non-testamentary documents relating to immovable property shall be accepted for registration unless it contains a description of such property sufficient to identify. That is, my lord, section 21. And then your lordship is aware of, my lord, 22A, where there is a prohibition of, my lord, registration. Then please see, my lord, next section 34.
Yes.
34, my lord, inquiry before registration by the registering officer. Subject to the provisions contained in sections 41, 43, 45, 69, 75, so and so. And no document shall be registered under this act unless the person executing such a document or the representation assigned so and so, so and so, provided that. So your lordship sees, once, my lord, the requirements of the registration act are complied with, my lord, the document can't be refused to be registered unless there's some, my lord, direction from a court. Then there's also, my lord, please see, it says that, my lord, it can't be registered, so they are bound to register all this. And, my lord, please see, Rule 58, my lord, of the rules issue says, my lord, I read out, it forms no part of the registering officer's duty to inquire into the validity of a document brought to him for registration or to attend to any written or verbal protest against the registration of a document based on the ground that the executing party had no right to execute the document, but is bound to consider objection raised on any ground stated below, that the parties appearing or about to appear before him are not the persons they profess to be, that the document is forged, that the person appearing as representative has no right to appear in that capacity, that the executing party is not really dead as alleged, that the executing party is a minor. So these are the only reasons on the basis of which registration could be refused. So your lordship sees, my lord, third parties' claims and all can't be entertained by the registering officer. Lord, there is also a judgment to this effect by the undivided court. I'll just pass on, my lord. It's, my lord, 2009, 1 ALD, my lord, page 321. I'm giving my lord, the Manupatra copy. My lord, the relevant paras are paras, my lord, 13, 14, and 15.
Para?
Para 13, my lord, please see. I'll read, my lord.
Yes.
Admittedly, the petitioner is a third party to the document that was presented for registration, which was registered by the registering authority. Petitioner admittedly objected to the registration of the document presented for registration on the ground that the property covered by the document presented for registration belonged to him, and that the legal heirs of the original vendors, taking advantage of the non-mutation of the names in the revenue records, have executed the document alienating the land covered thereunder, which was already sold to them to third parties. Since the petitioner is a third party to the document, the registering authority refused to consider the objections taken by the petitioner and informed him that the registration of the document cannot be stopped on the ground taken in the objection petition. Then para 14. The circumstances under which the registering authority can refuse registration of a document are spread in various provisions of the Registration Act and 80 rules made thereunder. It would be appropriate if a reference is made to the said provisions. The registering authority can refuse the registration of a document under various provisions of the Registration Act under Section 19 of the Registration Act if the document is presented for registration in a language not commonly used in the district. Then the registrar can refuse registration unless such document is accompanied by a true translation of the same into a language commonly used in the district. Under Section 20 of the Registration Act, registrar can refuse to register the document in exercise of his discretion if the document presented for registration contains alterations, erasures, etc., without any attestation. The registration can be refused under various provisions of the Registration Act as follows: under Section 21 of the Registration Act, unless the document contains description of the immovable property to identify the same. Under Section 22A of the Registration Act, registration of the document is opposed to public policy. Documents presented by a person who has no right to present under Section 34 Registration Act. The registering officer is not satisfied with regard to the identity of the person who sought to execute the document. Under Section 35, if the person purported to have executed is dead, the person who seeks to execute the document is incapacitated and is not competent to execute the document. The prescribed fee is not paid. Then, my lord, chapter, my lord, thing about Rule 58, which, my lord, is extracted. It forms no part of the registering officer's duty to inquire into the validity of a document brought to him for registration or to attend to any written or verbal protest against the registration of the document based on the ground that the executing party had no right to execute the document, but is bound to consider objections raised on any of the grounds stated below. That the parties appearing or about to appear before him are not the persons they profess to be, that the document is forged, that the persons appearing as representative, assigned or agent has no right to appear in that capacity, that the executing party is not really dead as alleged by the party applying for registration, that the executing party is a minor or an idiot. So these are the provisions. Kindly go, my lord, to para 21. Considering the nature and powers vested in the registering authority under the Registration Act and AP rules made thereunder, as narrated above, I am of the considered view that it cannot be said that the registering authority is not entitled to deny registration of a document unless such a document suffers from inherent defects as detailed under the various provisions, namely so and the rules made thereunder. If the registering officer is allowed to decide issues relating to title to the property based on objections raised by persons who are not parties to the document, then it would run contrary to the very purpose and object of the Registration Act. As stated above, it is open to such person to avail civil and criminal remedies under the provisions of the Registration Act and the laws in force. So, Lordship sees that's what, my lord, the endorsement has been made. The Lordship sees, my lord, petitioners have made a representation to stop, my lord, the registration. Then he made an endorsement saying that it's not his duty. If they have any, my lord, difficulty, they should appeal the civil court.
Unless there is an injection from the civil court.
Yes. And then, my lord, the other thing about the land, my lord, whether it's agricultural or not, my lord, they obtained proceedings for mutation on the basis of preliminary decree. And then, my lord, they filed a writ petition, my lord, for directions, my lord, for bringing about the mutation. And there, my lord, that is, in that writ petition, my lord, a counter was filed by the MRO stating, my lord, that it's all non-agricultural land. The lordship will find, my lord, that counter in the vacate petition, my lord, which is before my lord at page 168. My lord, the writ petition, my lord, WP 9046 of 2012 was filed by, my lord, the first petitioner, stating that proceedings for mutating the land in terms of the decree partition suit was granted. Still, there's no thing. Then, my lord, kindly go.
This is filed for what? 9046. This petition filed for what?
My lord, this was filed by the, my lord, first writ petitioner,
what
stating that, my lord, on the basis of the preliminary partition decree, proceedings were issued for mutating their names, my lord, in the revenue records. That had not been done. Complaining of inaction, the writ petition has been filed. And, my lord, here, therefore, an counter has been filed by the Tahsildar, my lord. Kindly go to, my lord, page 169. Para 4. With regard to the amendment mentioned in para 5 of the petitioner's affidavit, it is submitted to Sri K. Anjaya, my lord, the first petitioner, so have applied for grant of mutation before the Tahsildar for land bearing, my lord, so of an extent of so respectively, with reference to registered partition deed bearing 664 of 1966, and as per the orders dated 1910-2006 of the Honorable Court of the Second Additional Senior Civil Judge R.R. District, LB Nagar, Hyderabad, in a final decree in partition suit filed by so. Then the Tahsildar Kesari Mandala considered the mutation by the office proceedings so dated 19/6/2009 in favor of Anjaya and others. It is submitted. The matter has been got inquired locally. It revealed that prior to issuance of mutation proceeding order dated 19/6/2009 in file bearing number so, subject lands are already being converted into plots. It is submitted as and when the matter came to the notice that is plots non-agricultural, said orders could not be implemented. It is submitted on verification of the latest Pahani for the year 2015-16 of Rampally village, land bearing survey number 383, 384, 387, 340 to the extent of acres so, my lord, which is claimed by them, is recorded as plots in the possession column, which is non-agricultural. it is submitted to the present ground of possession of subject land covered by plots. As such, the order is dated so and so incapable. So, on the basis of revenue records, this was passed.
What is this? No, not revenue record. You say that on inquiry we came to know.
On inquiry and my lord,
So not bound by any, not bound by any record.
No, please
But,
no, it is submitted on verification of the Pahanis. Please see. Pahanis for the years 2015-16 of Rampally village. Land bearing survey numbers to the extent. Plots in possession column non-agriculture.
Senior, what is this partition deed 66?
Partition deed, my lord.
1966.
That is the partition deed is, my lord, I was telling your lordship. My lord, the ancestors or my lord, the great grandparents of the writ petitioners. Yes. All of them, my lord, they have acquired a total of, my lord, a little more than 59 acres of land. Then under this partition deed, 4 sets, each of them got 33 acres, 13 cents. Then all of them, my lord, sold that land to that Maganti Ram Mohan Rao, my lord, under a registered sale deed of the year 67. And my lord, by then they had already, there was an earlier agreement and a file number was also given. Your lordship will see, my lord, the original sale deed perhaps has that file number given.
File number saying that is converted.
Yes, my lord, yes, Gram Panchayat seems to have appeared a layout number is given, file number is also mentioned, my lord. Okay. Not the translated, the original. Yes, please see, my lord, the approved layout, your lordship will find in my material papers at page 163. And houses have been built in a lot of these things.
Yes.
Approved layout number 1 dated 21/9/67. Just because, my lord, the record is not available, they are saying it's the authorities are saying non-existent. My lord, the file number is also being mentioned. Somewhere I just point out.
This is in fact you see what they said that just endorsement, see the endorsement in bottom.
My lord,
Same this 163.
yes.
Endorsement given by the Commissioner Nagar.
Signature.
Now what they say that ఈ యొక్క కార్యాలయం నందు లభించిన జిరాక్స్ ప్రతికి నకలు.
This is an individual.
So it is not that. This is a copy or probably photocopy.
Yes, of an individual. The file number is also not given in one of the proceedings, I'll point out. But maybe continue, it's already 4:15.
Okay. Tomorrow. Same time. Same time tomorrow. But senior, what do you say about this 1960 there partition, 67 the sale was registered sale executed.
No, that is under challenge. In that suit, we have taken a stand. That's forged and fabricated.
But your partition also in fact gone now.
The partition is for 33 acres in one branch of 1966 owners. So only amongst that branch, that partition.
No, the partition is for the entire extent. Because 59 acres, partition deed, everybody, all the family members, 4 sets, trace out their title to that 66 partition.
According what is okay.
So that sale deed which they are claiming is under question in that suit, which is now decreed and appeal is filed.
No, that sale deed is not in question. What was question was a preliminary decree.
67, in fact, they are claiming under that only. So
They are claiming under 67 CLD
correct.
and filed that suit. We challenge that, saying they are.
No, there's
For-
no challenge to that. They
Kindly
only
see-
defended.
kindly
No,
see
no,
the-
suit for partition. You have filed only suit for partition.
Yes, they only filed a suit for
One-
partition.
Our suit is for partition as amongst the family members.
Correct.
There should be no
Where is
dispute
challenge to 1961 CLD?
because 67 CLD it was not in issue
Not-
at that point of
No,
time.
that is not challenge.
67 CLD they put into motion in the suit filed by them in 2060. There we took a stand. Your sale deed is forged and fabricated, not binding on us. That's the issue that is to be decided.
Correct, but that suit is decreed.
That suit is decreed, as I pointed out, appeal is
But
filed.
1961, in fact, see, suppose unlisted document we can understand, but 1961 is registered document.
That's what they claim so. That's what they claim so. That is the issue to be decided by the civil court.
The civil court, the challenge is to the my lord,
The
the
problem
partition
is that
decree.
two aspects for you. One is that partition decree which is obtained now is set aside.
Correct.
Secondly, their suit claiming
From
Titan
67.
is still
That
hold good.
67 document, I'll read it to the court. That itself will show how fraudulent
How can
it
be
is.
challenged? It's a document protected
How
under
it is
Section 19.
fraudulent.
It's not
Per,
challenged.
per se fraudulent.
What?
Per se fraudulent.
Okay.
Your lordship
But
may
I
have it.
think this requires some. it has to
That's
be-
why I argued only on the
This is
vacate stay issue.
No,
I
first
did
of
not
all, you
go
have to
into the
establish
merits.
locus.
Merits of the matter.
And my lord, your lordship says, what is the challenge in the writ petition? Challenges of the endorsement. That writ is not maintainable. Because, my lord, the registration can't be stopped at the instance of third parties. That is as per the statute and settled law.
That I will
So
point out.
that is it. All other
Here
things
we
are
can't.
different.
We can't say that is for the third party because they are also claiming.
No,
the
where
party-
is their claim, my lord?
They are
It's
only
set aside.
they are
They
only
have to show, my lord,
association.
1 minute. Both of us can't talk at the same time.
Senior, what is
That
the
is
problem
not-
is?
No,
Yeah.
what is their claim? Claim is a partition decree. Partition decree, my lord, obtained after the land was sold. And because
That
the
is in
very
dispute.
persons to him, my lord, they have not challenged the 1967 sale deed. And they could not have challenged in the nature of things.
No,
My lord,
correct, sir, but see,
so therefore, your lordship is the entire, my lord, I'm only concerned with the status quo granted there. The other writs, my lord, what is the locus? Now they have no title at all. That's why very generously say we will not alienate. They're not in possession. There's also a suit filed by injunction by individual plot owners and injunction was granted.
that will not
See,
have
my lord,
any-
this kind of a litigation can't be,
that
my lord, permitted.
injection that will not have any bearing.
No,
on-
injunction in respect of their plots.
Maybe that will not have any bearing on this.
No, your lordship, no,
Injection
please
may be
see.
position,
My lord,
only
now-
for position. That's
Now,
all.
my lord, the finding of the trial court is that it's a fraudulent decree. Lord, that should be taken note of and see my lord, the chronology of events. My lord, they make Maganti Raman Rao as a party for what purpose is not
And
stated.
that's why in fact,
He was
the paint
after
cup-
he's dead.
Suppose paint cup is there, at least then we will get something from the pleadings.
So
Anyway,
absolutely, my lord,
Many
we
will-
see when there's a, your lord,